As Anne just introduced, my name is Ashley Bargainquest. I am the leader of the criminal law section, and thank you all for being here. I wanted to let you know that the board for the criminal law section has grown a bit. We now have Nabil Ahmed as well as Danielle Jones coming back. But the most exciting thing is that today we are starting off the year right with Garrick Byers, the Statute Decoder. This is a long tradition of the section, and we are so excited to have him back again. Garrick is a noted writer, speaker, and litigator in California criminal law. Every year, he web publishes treatises on new laws and gives many presentations about them. He's written 3 different chapters in CEB's California Criminal Law Procedure and Practice and speaks at CEB criminal law webinars. He also speaks and coordinates at the California Public Defenders Association annual MCLE activity and is a former president of CPDA and is on their legislative and ethics committees. He is a certified California State Bar criminal law specialist and is currently working as a solo practitioner focusing on providing criminal defense for the indigent accused. We are so excited to have him. Thank you so much. And with that, I just want to let everyone know if you have questions, Garrick is glad to take them along the way. Just put them right in the Q&A. He's going to be responding to them. And if he misses one because he is passionate about these new laws, then I will pop in to bring them to his attention. Otherwise, everybody enjoy. And if you ever have any questions, concerns, or ideas for criminal law section events or MCLEs, please don't hesitate to reach out to me. And thank you so much. Take it away, Garrick.
Well, thank you very much, Ashley. I appreciate that fine introduction, and I'm thrilled to be here. As some of you know, I've done previous presentations this year. This one's the best. It's the most refined and the most relevant new laws. Let me see if we can get screen sharing going here. And we should have my slides. Hopefully just the slide that says, we'll start with new laws for 2023, the first slide, criminal law section for you all. And so let's take it away. So today's goals, I'm going to tell you about some of the most important criminal law statutes, rules, and forms for this year. This presentation gives you a first solid exposure. My written materials, now my understanding is that the latest edition of my new laws treatise, which was finalized 2 days ago, and today's slideshow presentation are going to be sent out afterwards, along with your certificates of attendance. That's my understanding. So those written materials cover more than today's slideshow. Look them over soon and use them later as a reference book. So some important features of this year's new laws. So a lot of the new laws this year are motivated by social justice for juveniles, for low-income people, for racial and ethnic minorities. Vocabulary. This year, incarcerated person is used a lot in the new laws instead of inmate. A continuing trend there is often used instead of he or she. And person is often used instead of defendant or minor. This year, for the first year in a long time, many years, there are no major electronic filing laws or rules this year. I guess they're getting pretty saturated into the criminal practice. There are a small number of background checks that are slightly eased this year. I hope that's a trend, and so I cover them. And there are some hortatory laws this year, laws that urge something. So here's an example of a hortatory new law, Penal Code 17.2. Let me tell you how I do my slides. Usually off on the left is an AB Assembly Bill or SB Senate Bill number, and they are all statutes of 2022. And then after that, it's the section or the main sections that it adds. Sometimes there's additional things up there. So here's what it says. It's the intent of the legislature that the disposition of any criminal case use the least restrictive means possible, that the court shall consider alternatives to incarceration, including, and then they list several specific types. And then C kind of goes the other way. The court has discretion to determine the appropriate sentence according to the statutes and the sentencing rules. I call this a hortatory, an urging law, because it doesn't actually require anything. It says, this is our intent. This is what we want you to do. So, and there's a lot of questions about a hortatory law. Should there be a new sentencing rule of court to help make this go? Because it says discretion according to the rules of court. What did there be a rule? Well, there's a statute. Real bigger questions. So what court actions or statements show consideration? I can see this one on appeal, where the appellate justices says, and you say, well, Your Honors, the judge said or did nothing to show that the judge was applying, that she was applying the least restrictive alternative. Well, counsel, we assume that the judges know the law, so we assume that they did that. Denied, counsel. Does the defendant forfeit this consideration if the defendant, Your Honors, it says the judge shall consider the alternatives. Well, counsel, you didn't bring it up, forfeited, denied, counsel. So it's urging the court. I recommend that you remind the court that you're urged and bring up a specific program or two, and ask to have the record reflect. If the judge says no, Your Honor, can you, why not? Put it on the record. All right, here's another hortatory new law. Now this one kind of goes both ways. It kind of goes, we urge you to lock them up and we urge you to divert them. It's a sort of a, well, there we are. Now this one was already effective last September 30th, and it will sunset January 1, 2026. So it addresses, it's the legislature addressing what it apparently hopes will be a transitory, a temporary problem, maybe pandemic caused or whatever, of petty thefts, a lot of particularly organized petty thefts and repeat petty thefts. So it does three things. So the first thing, it amends Penal Code Section 853.6. 853.6 is a huge statute. It's and very hard to read and so forth. The main thing to know about it, 853.6, it's the statute that authorizes most people charged with a misdemeanor to get to be released on a citation instead of being arrested and booked. And what this one does, there's reasons listed in 853.6 why the police, the arresting officer, sheriff, whatever, or the jailer might not release a person, might hold a person. There's six or seven of them. And so this one adds a couple of reasons. I call it hortatory because there's already a lot of reasons not to release somebody. And this one doesn't really add very much. It's kind of an urging. Hey, guess what? We added one concerning petty thefts, so that if they've been cited, arrested, or convicted for a misdemeanor or a felony theft from a store in the previous 6 months, or there's probable cause to believe they've taken part in organized petty theft, organized retail theft. It doesn't add very many new reasons. It's kind of urging that if it's theft, consider keeping them locked up. Then there's 978.5 is also amended. This is the statute that authorizes bench warrants in cases of failures to appear. And there's like 6 reasons why a bench warrant might issue. The main one being they didn't come to court. So there's a 7th one added. If the defendant has been cited or arrested for misdemeanor or felony theft from a store and was failure to appear on that charge on a previous occasion, then again, the court is urged really to give give them a bench warrant if they don't appear. But the court already had the authority, so it doesn't add very much. It just kind of urges things. But then here's the third part of it. It goes the other way. It adds a new diversion or DEJ program, PC 1001.81 at SEEK. Again, effect and the same with by the way, these previous two, the same ones. They sunset on January 1, 2026. So this says the city or the county prosecutor or probation officer may create a diversion or deferred entry of judgment for program for persons who committed theft or repeat thefts, which is what they're really getting at here. And so this is why is that here? There's already authority for petty theft diversion programs. There are a lot of counties around the state, maybe most of them, already have a petty theft diversion program. So why is this here? It's a hortatory. It's saying, hey, look, pay special attention to the repeat ones. They can get petty theft diversion too, at least if you create a program that allows it. So it's a kind of an urging thing. All right, so let's get on to some real substantive, although this one is also discretionary, but it's pretty important. This is criminal record relief for felons who went to prison. This stems from 1203.4, which has been around forever. Everybody, it's the main what you call a dismissal or expungement. It's only partial. None of these are complete. But the main thing it does is it makes it easier to say to a prospective employer or prospective certain other people, hey, I don't have any criminal record. I wasn't convicted and so forth. Well, who knows what that really means. But so 1203.4 was for misdemeanors who completed probation. Then it was expanded in a number of ways. 1203.41 was recently created to cover people who got a felony but served that in county jail, a county jail felony, a felony sentenced under Penal Code Section 1170, subdivision H5, county jail felons. It's always discretionary. It's similar to 1203.4 relief, but it's always discretionary. 1203.4 is mandatory if they successfully completed. This is discretionary. There's a waiting period after completing the sentence of 1 year or 2 years, depending on what it was. This is now expanded to felons who went to prison. The only categorically ineligible are people who have to register under PC 290 as convicted sex offenders. But it's discretionary. You're not going to get it for your person who did it 20 years after battering somebody almost to death, but you're probably going to be able to get it for your gun case on which you went to prison, maybe other cases on which you went to prison. So that's a cool one. This one should be retroactive, by the way. So if you've got somebody who comes into you and says, hey, I can't get a job, I did my my time, look at 1203.41, see if that will help. Okay, so now here's one that you probably have read about in the paper. It's kind of cool. It's called the Freedom to Walk Act, no ticketing for jaywalking, unless there is an immediate danger of a collision. So what this does, there's about 15 jaywalking sections. Who knew how many different kinds of jaywalking there were? You know, if there's an overpass over the road and you just cross on the road, that's jaywalking. A bunch of others. So every one of them has the following language added: a peace officer shall not stop a pedestrian for a violation of the covered infraction, they're all infractions, unless a reasonably careful person would realize there's an immediate danger of a collision with a moving vehicle or a specified device. Bicycles are examples of those. And one of these statutes next year, by the way, covers bicycles, not just walking. Let's see what we got here. Okay, so this is one of these social justice ones, or racial and ethnic minority ones, because that's one of the reasons to enact this, that this seems to have been used disproportionately on racial and ethnic minorities as a kind of a profiling thing. So they now make it harder to get those tickets. You know, I came to an intersection the other day, very busy street, nobody in sight at this time. I had red light. I thought, gee, maybe I should go. And I thought, gee, maybe chaos lies that way. I don't know. I waited for safety reasons. Well, what the heck? You need a lawyer to cross the street now. All right, repealed. Loitering with intent to commit prostitution. I never had one of these cases, so I think they're rather rare. But so 653.20 was the definition, 653.22 was the crime. It also adds an evidence code section. Before this, the law prohibited loitering in a public place with intent to commit prostitution, or directing, supervising, recruiting, or aiding a person loitering, and it's a misdemeanor. This bill repeals that prohibition, and it provides for a petition for dismissal and sealing of the loitering convictions that occurred in the past. There's also an amendment to the evidence code, 782.1. It's one of those sections that has to do with introducing prior sexual offense conduct. And this one, the only change is it says now former 653.22. Okay, so next, theft of dogs is expanded to include companion animal as defined. This is a misdemeanor if it's 950 or less. It's a felony if it's greater than 950. Companion animal, slow down. Companion animal is defined as an animal, a dog, a cat, any household pet kept for companionship, emotional support, service, protection. It excludes feral animals. You know that cat that you put out food out the back door. After that, it goes its own way, comes back the next day at dinner time, you put more food. That's probably a feral animal, maybe doesn't count. The important part of one of the important parts of this is 491, which says companion animals. And the way I do the new laws here, take a look at this one. So the new part of a new law is in blue and italics. And the old part, the deleted part, is in red with a line through it. There are dogs down at the bottom of that. And then the language that is continued, that is unchanged, is done in black or gray. So dogs is crossed out. Companion animals are personal property. Their value is ascertained in the same manner as the value of other property. I think that the intent there is you can't say, oh, my dog meant my whole life to me. I want $100,000 in restitution. No, what would a pet store pay for it is what I think is getting at there. All right, background checks. So there, I covered two of these. You might not get many of these, but as I said, I'm hoping that these will start a trend. So teachers. So before this law, the law required the Commission on Teacher Credentialing to deny an application for a credential or the renewal of a credential for a person who's been convicted of a specified drug offense. It's mainly possession. This bill prohibits a record of conviction for possession of specified drugs, mainly the ones that have been reduced from felonies to misdemeanors or even to an infraction that is more than 5 years old, and for which relief was granted, 1203.4 or whatever, from going, those will no longer go to the committee. They can no longer be used to deny a credential. And then there's another one. This one may come up in your practice a little more often. It's a simplified background check for certain applicants for certain community care licensed facilities. Anybody that wants to work in or operate a community care facility, maybe it doesn't cover all of them, but certainly most of them. The California Department of Social Services, CDSS here, has to clear you. A criminal record will bar many applicants, but others can get an exemption from a criminal record and get their license to work in a community care facility. So this is a kind of a ban the box for background checks. Ban the box was a big deal a few years ago, that most job applications used to ask for, have a box. Do you have a prior conviction? Check. Oh, we're not going to look at you anymore. So ban the box that you can't ask that until you've decided to offer the job. Then you offer the job conditionally dependent on the background check. It makes it more likely that a person with a criminal record is still going to get that job because the job already wants them. And then they look at the criminal record. And so hopefully it makes it more likely. That's this kind of thing too. The applicants no longer have to check a box, no longer have to say what their priors are. They do have to get a live scan, a fingerprint, an electronic machine. You've all had one as lawyers, so that the bar can check your background, so you know what they are. And what this will do is hopefully it will streamline the process, make it faster, and make it more fair, make more people be able to get that exemption. Okay, so now a more serious one. Vehicle manslaughter, sideshows, and specified speeding is added to the what I call the statutory gloss of gross negligence. Gross negligence as used here may include, so it's not a limit, it's not, this is the only thing, and so I call it a gloss, based on the totality of the circumstances, any of the following: participating in a sideshow as they define, and I'll go into that, an exhibition of speed, speeding over 100 miles an hour. So there's more things added to the gross negligence that can make vehicular manslaughter. Okay, so Here's a trivia question. So Vehicle Code 23109 subdivision I2 defines sideshow. It's an event in which two or more persons block or impede traffic on a highway to perform motor vehicle stunts, speed contests, exhibition of speed, reckless driving for spectators. Okay, so question, where does this name sideshow for that kind of driving, where's that name come from? If you come from Oakland, you may know, in fact, you may know just from where you are, but here's where it is. I got this from an official legislative report. I didn't invent the language, they used it. They say it began in the 80s in Oakland, in mall parking lots. So it was literally a sideshow, not on the road, in a side to the road, a mall parking lot. And the originals were just to show off customized cars. They say in the 1980s, they developed into larger events. The guys with cheap cars, they say, started doing stunts, including donuts. And here's what, ghost riding the whip. I never heard of that. Maybe I should get out more. Exiting a moving vehicle and dancing beside it and around it. All right, I've never taken part in a sideshow. Sideshows grew in popularity, moved out of mall parking lots, on the streets, highways, so that's where it comes from. Okay, false personation. This now includes websites and electronic means when it's done to defraud, and it amends a whole series of statutes in the Penal Code, beginning with 538D that covered impersonating a peace officer. Anybody other than who is a peace officer who willfully wears a uniform, that certificate, they flash a badge, they fraud. Their intent is to fraudulently impersonate a peace officer or fraudulently induce the belief that they're a peace officer. So now that is extended to the web and electronic means, which I think is email, who willfully and credibly impersonates a peace officer through an internet website or other electronic means for the purpose of fraud is guilty of a misdemeanor. And the other ones in this series are firefighter, a public utility employee, a certain government employee, certain search and rescue team members. Okay, so one count of this has been a hot topic. One count of grand theft is committed by distinct related thefts motivated by one intent, impulse, and plan, totaling over $950. In other words, so these are your repeat theft people, the ones who you hope to get diverted through that extra hortatory program. So they commit a string of petty thefts. None of them are over $950, but in the aggregate, they're over $950. I want to charge a felony. So PC 487 subdivision E says, now, if the value exceeds that $950, and if they're motivated by one intent, one general impulse, and one plan, then it can be charged as a felony. Now, there's an uncodified section 2 of this bill. Now, listen, if you're unsure about how to interpret a statute, go to the original bill. It's California Official Legislative Information, something like that is the site. California Legislative Information is the official site. It's got all these bills back many years, 20 years. And you get the original bill. A lot of them have uncodified introductory sections. This one does. And this says the amendment of PC 487 is declaratory of existing law in People v. Bailey, a 1961 case. But when you shepherdize that case, you'll find there's a much more recent case that this is not straightforward. What is one intent, one impulse, one plan is not straightforward in the law. So if you get a case like this, do your research on it. Okay, mental health diversion. This is a big deal. This might be used by every one of you during your practice this year. The eligibility criteria for mental health diversion under PC 1000.36 are changed. In my view, they are considerably improved. I don't think they're loosened. I think they're improved. And here's where it becomes important to see what's deleted, what's added. So a defendant, it used to be that the court had to, I'm looking here on A1, the court had to be satisfied that the defendant suffers from a mental disorder. Well, counsel, I realized that they were hallucinating, but I'm not satisfied that that was a mental disorder. Now the defendant, you show the court that the defendant has been diagnosed with a mental disorder identified in the Diagnostic and Statistical Manual. There are some exclusions. They're listed in here. There's some that are definitely included, some that are definitely excluded. They're listed in the statute. It has to be, or evidence can be provided by a diagnosis or a treatment for within the last 5 years by a qualified mental health expert. It's not going to do to have mom say, I think my son is crazy. You got to have a bona fide mental health expert. And it's got to be something that's in the DSM. It can't just be, this guy's still traumatized by the stub toe he got 2 weeks ago. It's got to be a diagnosed thing. Okay, number 2, this might be more important. The defendant's mental disorder, no longer does the court have to be satisfied. It's court still's got to be satisfied, but differently. Used to be, Your Honor, I think it was a contributory clause. Well, I don't, counsel. So now the defendant's mental disorder was a significant factor in the commission of the charged offense. If the defendant's been diagnosed with a mental disorder, the court shall find that the mental disorder was a significant factor unless there's clear and convincing evidence that it was not a motivating factor, causal factor, or contributing factor to the defendant's involvement. In other words, what's happened is the burden has shifted here. From the defense that had to convince the court it was a contributing factor to the prosecution. Now, proof of that mental disorder within the last 5 years, it's got to still be existing. You're going to have some burden here. It's going to be assumed to be contributing unless the prosecutor shows by clear and convincing evidence that it's not. We're going to see how this works out in practice, but I think it's a little more realistic. Okay. Limits on admissibility of creative expressions. For example, songs about crimes. You may have read about this one in the newspaper. Maybe it's not going to come up except in major crimes, murders, kidnappings, rapes, because it's a lot that goes into both introducing the expression and then rebutting it. So creative expression is defined as just about any kind of creation, not limited to music, dance, performance art, poetry, and so forth, but most commonly it's going to be your client has written a rap song about crimes or a poem about crimes. So this bill requires the court in balancing the probative value of it, because you object to that, come in. The probative value substantially outweighs the minor Go slower, Mr. Byers. Got to remember that. How am I going to get through if I don't rush? So the prejudicial value substantially outweighs the probative value, is the most common thing. It can be also consumption of time, undue consumption of time, undue prejudice. Okay, in balancing that, the court has to take certain factors into account. That the probative value of the creative expression for its literal truth is minimal unless there's certain conditions met. How close is it to what was actually done? How close in time is it to what was done? Does it reveal evidence not public? And the court has to consider the possibility that the jury will treat this creative expression as propensity evidence, propensity for violence and criminal disposition. Or that this will inject racial bias. Hey, only Black people make this kind of song or whatever. And that also, if proffered and relevant by either side, testimony, expert testimony on the type, on the expression, that it demonstrates that it does or doesn't introduce racial bias or evidence, has to be accepted by the court. Okay, onward. Misdemeanor child abuse. Hey, if there's any questions, don't forget to put them in the Q&A. I don't see anything in there right now. All right, misdemeanor child abuse and elder abuse is added to the list of gun prohibition for 10 years. You probably know that PC 282, you may not know the number, it's PC 29805, is a long list of misdemeanors that prohibit a person from owning or possessing a gun for 10 years. Added to that list now is certain child abuse, PC 273A, certain elder abuse in BC 368 BC or D. Can't have a gun for 10 years. It's a misdemeanor. they can go to county jail on that one. Okay, the Racial Justice Act has been expanded and made retroactive in stages. So the Racial Justice Act, basically, it says that the state cannot seek or obtain a conviction based on the person's race. It's just race that's covered. It's not a lot of other characteristics, sexual orientation or whatever. And it defines, it talks about how it's proved that this was based on race. The most obvious one is a lot of racial epithets are used, a lot of racial stereotypes are used in obtaining that conviction. Can't do that, and you can get relief if that's tried. The more difficult ones are the statistical type ones. It just seems like the black people get more serious charges, brown people get longer sentences, and so forth. So the racial, it's only one section and it's fairly short, but it's actually very difficult to apply. And as a result, mostly it's being used in major cases, but it can be used in any case. And it's been expanded this year in a couple of ways, in two ways. One, there's been some ways of making it easier to prove. What if you think that it's the judge who's racially biased? And you make a motion, I want a Racial Justice Act relief, I want a new trial, I want a different judge, I want, because of what the judge is doing, names or whatever. So the judge has to disqualify themselves from hearing that challenge. It's unclear what happens if the challenge is denied. I think the judge comes back on the case, but we'll see. The defendant is entitled to discovery on a Racial Justice Act issues. I want a record of all the black people and all the white people you've prosecuted for this crime, or all the sentences that you've given for this crime. There's been limitations on that discovery if that discovery would reveal privileged information. There's now some ways to get around that, redaction or protective orders. And then finally, some of the proof requires statistical evidence. I mentioned that. This bill, now you can prove some of these things by other than statistical evidence. You have to do them in concert. It's complex. If you get a case where you think that race is an issue, or where you think race was just seems like it was unfairly used, the arrest, the trial, whatever, take a look at the Racial Justice Act. Now, the Office of the State Public Defender has a whole listserv on this. They got experts on this, so contact them also on this one. All right, the second one is, originally the Racial Justice Act said it applies prospectively only in cases whose judgment has not been entered prior to January 1st, 2021. Now, it now is applying retroactively in stages, depending on the case and the reason for the sought for the relief. If it's a death penalty case, if it's a life without possibility of parole, even if it's over with, starting this year, you can bring an appropriate writ, a habeas corpus writ or type writ. Or if it's an immigration case and deportation is imminent, then you can bring that. There's a new category coming in 2024, 2025. My point is this: if you have a case in your background where somebody's sitting rotten in prison or someone's about to get deported, and you just know that this conviction wouldn't have happened if the person had not been black or not been brown or whatever, take a look at the retroactivity provisions and see if that person is eligible to bring an action. You do have to be careful with habeas corpus, particularly in a death case, because maybe you can only bring one single habeas corpus. So you want to bring all your claims in at once. But take a look at this if you've got a case like that in your background, so to speak. Okay, so onward. The California Public Records Act is recodified and made user-friendly. Okay, so look, I know that few defense attorneys have used the California Public Records Act to get information about their case that they're not able to get through penal code discovery or just through having a sleuth investigator go around. There's two reasons why the CPRA hasn't been used. One, it is stingy in criminal stuff. It is stingy, but it can get you some records. But the other reason, it's been extremely hard to read and understand. The main section has just been written inside out and backwards. It's been recodified. This is a year old. This was done last year, but its effective date was postponed a year so that everybody could get used to this change. I might have dawdled a little bit in getting used to it, but here we are, effective 2023. And it really does recodify it in a way that's much easier to understand, much easier to read. It doesn't have a substantive change. It's not supposed to get you new information, but it is easier to read and understand. So now, Part 5, specific types of records, Chapter 1, crimes, weapons, and law enforcement, Article 1 of Chapter 1 of Part 5, law enforcement records generally. That replaces, law enforcement records replaces the old, nearly unreadable PC 6254 subdivision F. It's now 7923.630. You can go through this at your leisure. And I'm not going to do this in any great detail because otherwise I'll never get through this presentation. But so here we go. There's a statute, 7923.6 of records available to victims. They're somewhat different than the records available to other people. Record publicly available information about arrest. This is your newspaper says so-and-so got arrested. This is where they are. This is their bail. This is the charges. That's where they get that from this. Publicly available information about calls for help or assistance. You get your police call, somebody called because there's chickens crossing the road. They thought this was unusual. That's where they get that from. Disclosure, licensed private investigators. There's actually a section for licensed private investigators, 7923.620. Now, the relief wasn't expanded. There's still PC 841.5 that says a police officer or law enforcement organization cannot disclose to anyone arrested or who may be a defendant the contact information on a victim or witness. It's still the statutes still say that if it causes danger, release of information can be withheld. If there's dangers to victims or witnesses or confidential informants, they'll allow the victims to withhold their names if it's a sex offense. And there's a lot of other delaying tactics as well, but it's easier to read, it's easier to understand. Give it a whirl. Okay, let's see. Let's move on. A statute of limitation. You'll probably never run up against this one. I include it because if you're like me, I'm sure you are, one of the first things you look at when you get your new compact penal code is what's changed in the statute of limitations. This is it. It adds 801.8. And it has to do with mandatory reporters. Child Abuse and Neglect Reporting Act makes certain people like teachers and social workers mandatory reporters. They have to report known or suspected instances of child abuse. There's a similar one for sex abuse, but that isn't this one here. So it's a misdemeanor for the mandatory reporter not to report. It had the 1-year statute of limitations on misdemeanors. This year that is expanded in cases of child abuse or severe neglect as defined. Now, it doesn't have to be reported until 1 year after discovery, but the discovery can't be any later than 4 years after the offense. Okay, this one's, well, medical evidentiary exams for domestic violence, they're free of charge and they're enhanced. So this adds PC 11161.2 way up there in the penal code where nobody ever looks. The cop says to the DV victim, ma'am, I want to take you to the hospital for anything. I know it's going to cost money, it's going to charge, it's going to be inconvenience, you're not going to look for the right things. It has to be free now, and there has to be special attention paid if strangulation is suspected. Okay, unserious ghost guns. You probably read about this in the newspaper, seen it on TV. And well, if you're like me, you didn't quite know what a ghost gun was. It's simply a gun that never had a serial number. I suppose a serial number being erased, taken out, is also a ghost gun. It's these artificial guns that are made buy unlicensed people out of parts, and they don't have any serial numbers, and they never did. Those are called ghost guns. So this is now heavily regulated, darn near completely illegal. It's been done in a very clever way. You probably know the firearm has been for a few years defined also to include the frame or the receiver. Now that definition is even broader. The firearm precursor part is an article that may readily be assembled as the frame or receiving. And a firearm is now defined not just as just those main any precursor part is a firearm. There's some litigation in there for sure. And now the transfer or sale or possession of an unserialized firearm precursor part is generally prohibited. It's a weaselly worded statute, but you may get a charge like that. There's a definition, there's a statute, and I don't have a section here because there's dozens of them. You'll have to look it up by the AB number. You know, if you get a charge, it's going to be in the charge. But look at the original bill. There's about a zillion parts to the original bill. And if your client's got a person with an unserialized gun as of January 1st, 2023, has a year to go to DOJ to get a serial number for it. So you tell all your clients, hey, get down to DOJ, get your guns, have a serial number. Of course, you're going to have to stand in line behind all the other people that are waiting to get their ghost guns regulated. But they do, because starting January 1st, 2024, a person can't purchase more than one completed receiver in a 30-day period. And now it's got to be done through a dealer, obviously. And prohibited gun possession, it means that for 10 years, cannot, if they got convicted of manufacturing an unserialized firearm, it's also a 10-year gun prohibition. All right, 3D printing. You probably heard about this one. It's a little more exciting. 3D printing of guns now requires a license. And this is also done in a clever way. Just one statute here, 29010. So unless you were a gun person, and I'm not, you didn't know this until you read this. So federal law requires a manufacturer of firearms to be licensed by the federal government. Before this bill, California law required federal licensing, manufacturing of 50 or more firearms in this state. You had to get a California license. If you had a federal license, you only made 25. You didn't need a California license. Now you do. Now you do. Even if you don't have the federal license, if you manufacture in this state 4 or more in a year, you got to have a California license. I guess you get to do 3. I've only one, no ghost guns. This bill prohibits a person, unless a licensed or firearm manufacturer, from making any firearm or precursor part by a 3D printer. Just outlawed. Okay. So onward, habeas corpus petition allowed when significant dispute about develops about expert evidence. So several years ago, a provision was added to the habeas corpus laws that if the defendant was convicted based on expert evidence, and the expert evidence was later disproved, client could make a writ of habeas corpus. That's been expanded now. Just if that expert evidence has come into serious dispute, and that serious dispute might have caused a different result, then they can also file a petition for a writ of habeas corpus. Okay, this is a big deal for immigration people. It's untested. We expect it to work. We're not positive. But so let me first get into what nuisance is. Nuisance is defined in PC 370. It's anything that's injurious to health or is indecent, offensive to the senses, and obstruction interferes with the comfortable enjoyment of life or property by an entire community or neighborhood, or by a lot of people, or obstructs the sidewalks. All right, so PC 372, every person who commits or maintains a public nuisance, the punishment for which is not otherwise prescribed, or who willfully omits to perform any legal duty relating to the removal of a public nuisance, is guilty of a misdemeanor. Now, I underlined that phrase here, the punishment for which is not otherwise prescribed. That predates this law. That's important to keep in mind. Okay, so here's the law. It's 372.5. The defendant can only do this by a plea bargain. If the defendant is sentenced for a violation of nuisance based on a plea bargain that includes the dismissal of, and what I have here is misdemeanors, but we'll see it applies to infractions and felonies too. Charges of cultivating, manufacturing, transporting, giving away, or selling a drug, or offering to do those, or unlawful possession or use of a drug or paraphernalia. And if that charge is dropped in return for a plea to nuisance, then the person gets a nuisance conviction, but gets the misdemeanor drug sentence. 372.5A, this is also applicable to infractions. 372.5 subdivision C, this is also applicable for felonies. The person gets a felony sentence for this nuisance. Now, what's the deal about this? So this is a big deal for non-citizens because they avoid, or hopefully they avoid, a drug charge on their record, which in many of them it's automatic deportation, and others it's nearly automatic deportation. So they want to avoid drugs on their record, and this is a way to do it. It's similar to, but don't confuse it with, a wet reckless. Both 372.5 and VC 23103.5, this nuisance wet reckless, both can only be reached by a plea bargain with the prosecutor. But the differences kind of end there. The benefit to the defendant from a wet reckless is the penalty is usually less. The benefit to the prosecutor counts as a prior DUI, and both avoid the risk of trial. With this nuisance, the benefit to the defendant is they avoid drugs on their record, and the benefit to the prosecutor is they get the same penalty as the drug charge, and both avoid the risks of trial. Okay, onward here. So a transfer of a minor to adult court requires clear and convincing evidence that the minor is not amenable to rehabilitation in the juvenile court. If we were having an in-person session here, I would say raise your hands if you do juvenile law. And if nobody raised hands, I'd skip this one. But I'm going to have to pretend somebody raised their hand. So here's the deal about this. This is why this is important. I want to go over it in detail. So PC 707, W&I 707 subdivision A3 has been amended in order to find that the minor should be transferred to a court of criminal jurisdiction, that's the adult court. The court shall find by clear and convincing evidence the minor is not amenable to rehabilitation while under the jurisdiction of the juvenile court. But the rule of court has not been changed. It's been changed January 1st in other respects, but it still says preponderance of the evidence. So why is that? Well, my guess, and I'm guessing, I don't have any inside information, is this. It takes a while to change a rule of court. And the change that was already in the pipeline for effective January 1st was in there and couldn't be stopped when this new law got enacted. But I'm sure I'm confident we're going to get a new rule of court, a change again in 5.770 that changes it from preponderance to clear and convincing fairly soon. Meanwhile, if you got one of these cases and the DA or the judge says, hey, the rule of court says preponderance, no, change this effective January 1st to clear and convincing evidence. I have a list of other rules of court that were changed in accordance with this one. Okay, this one, you probably all know this, but just in case you didn't, last March, all the sentencing rules of court were changed to align with the change that took place January 1st last year to PC 1170 that said that aggravating factors have to be proved beyond a reasonable doubt in order to go above the middle term. Okay, so look, judicial council forms. So there's a whole bunch that are revised, and a few that are new, scattered through. So when you're going to use a form, I would go check and see if your form's been revised or if it is new. Okay, by July 1st, 2023, and I believe that this is in progress and is likely to be done on time. The Judicial Council has to make a new rule of court for juvenile law, a matrix of offense-based classification for the juvenile courts that are making commitments to secure youth treatment facilities. So you know the DJJ is supposed to close on July 1st, probably will. And minors that are locked up will be locked up at the county level, mostly in the secure youth treatment facilities. This is puts a new sentencing burden on the local juvenile courts. So there's going to be this matrix developed about that. If you do juvenile law, you want to know this. Okay. And electronic monitoring for juveniles. Used to be juveniles didn't get any credit against sentence for electronic monitoring, but now they do get credit against sentence for electronic monitoring. Just they don't get extra credit, but they do get at least those days. But also, now the juvenile court has to review electronic monitoring every month to make sure that it's not going on longer than it's necessary for that to go on. Okay. There's something called the Youth Bill of Rights that used to apply just to DJJ, Division of Juvenile Justice, which is closing, and now they'll be kept on the local level. The Youth Bill of Rights is now made to apply to those, and it's been expanded somewhat. And the three biggest expansions. First of all, there are a lot of youth parental rights that apply, both for men and for women. So if you got a client, a juvenile client who's looking to who's going to get locked up, and the female's pregnant, the male's got a pregnant wife or girlfriend, look up these parental rights that are now applied. They're both birth, post-birth alternatives, can't be locked up, can't be shackled while giving birth, a bunch of stuff. And it prohibits discrimination against youth on the basis of gender expression or on the basis of immigration status. Room confinement. This is a dodge around solitary confinement for juveniles. There have been rules about restricting solitary confinement, but if it's administrative only, it's not done for punishment, it's for administrative reasons. They're in a locked room. Got to be a bathroom in the locked room. Geez, you'd think that'd be elementary. No, got to make a statute about it. Okay. I'm not going to do this one in detail. It's way too complex for the time available, etc. But W&I 782, dismissal of a petition in the interest of justice, been expanded. It now can be done at any time, regardless of whether the petition was sustained at trial or was by admission or by plea agreement. There's some specific mitigating circumstances added to that statute. If you've got a juvenile or a former juvenile who wants to get their record sealed, look in 782. There's a lot of statutes, but this one in particular is expanded. Okay, and here's more about it, but I'm running out of time. Okay, prison wardens are required to develop judicial process like summonses and subpoenas to inmates. This has long been the law for county jail. Why hasn't it been the law for prisons? I don't know, but now it doesn't have to be the warden, but it's got to be somebody in the prison. If you deliver a summons for the person or a subpoena, they got to go and give it to the person. Okay, now. There's a new article of the Penal Code. You may already know this, but there's been a lot of statutes enacted in the last few years that permit recall and resentencing. There's the one that's long been known about within 120 days of a felony sentence, but also there's now felony murder recodified or reformed. You can get recall and resentence if you got convicted of a 3-year drug prior that's been repealed. You get resentenced for if you got a 1-year drug prior that's now been repealed. These are now put into a new article called recall and resentencing. And so you need to be aware of it. Okay, compassionate release has been recodified and streamlined. It's been taken out of 1170 and out of 1170.02, where it was for a little while. It's been put in this new recall and resentencing article, and it has been expanded and made easier. For example, it's no longer required that the person has to have 24-hour care, and it includes certain functional impairments. There's now a presumption. If it gets to court, if the prison sends it to court saying this guy ought to be resentenced, there's a presumption that the person will be resentenced, and the court has to appoint counsel for the person. So hopefully we will see more of these compassionate relief. If you got an old prisoner in your background, older than me, maybe or who's having serious health problems, look at this to see if you can get them out. Jail discharge, information and phone calls have to be provided. This is interesting. The sheriff has long had discretion to discharge a person on the day of discharge as early as is in their best interest. Can permit the person to stay up to 16 hours for transportation or for entry into a program. This bill now requires the sheriff to make these release standards and processes available to the defendants in writing. They'll probably add it to the prison handbook. And it also grants a defendant in or recently released from a jail up to 3 free phone calls from the jail to plan for a safe and successful release. It remains to be seen how this is going to be interpreted, but here's what I envision. It says, or recently released. So I got released. It turns out it's a holiday, the buses aren't running, or it's late at night, the buses. I want to come back in and make my 3 phone calls to get some transportation. I think that's allowed under this. We'll see. Okay. Prisons and youth in residential placement or detention centers have to get free phone calls to incarcerated persons. Now, this is prisons and youth in detention centers. They have to get free phone calls. The idea is to stop this dramatic overcharging for phone calls from jails and youth facilities. Why doesn't this cover county jails? According to the legislative history, the theory is that the jail welfare fund already takes care of this. Well, it does in some places, but it doesn't in others. So right now it's prisons and youth detention centers. Okay. A restriction on a diversion. This is a diversion of by the court over the DA's objection, 1001.95. It no longer can be given for domestic violence or for violation of certain protective orders. This was actually effective last July 1st. Okay, flash incarceration. This was supposed to sunset on January 1st of this year. Not surprisingly, it got extended to January 1st, 2028. Okay. Eligibility for traumatized veterans to petition for a lower sentence. So this amends 1170.91, which since 2015 said that if a veteran had suffered from sexual trauma, brain injury, post-traumatic stress disorder, mental health problems as a result of mental service, the court had to consider this a factor in mitigation. It wasn't made retroactive because the theory was that it will now be considered. Well, it wasn't. So it's now been made retroactive. This bill allows a defendant meeting these criteria to petition for recall or resentencing regardless of when they got sentenced. And it does exclude certain sexual offenses from this. It doesn't mention that the existing law limited this to people sentenced got a determinate sentence. So this has now been expanded to people with an indeterminate sentence. So go for it. Okay, so a petition for relief from a conviction can't be denied solely because an unfulfilled order of restitution or restitution fine. We'll see, this applies to almost all of these reliefs that people can apply for, including under PC 17 and including a parole provision. It means that the judge can't deny relief. Counsel, your client still owes $10,000 in restitution. Counsel, your client still owes $100 in restitution. Relief denied. No longer can that be the sole reason for denying relief. I have some questions about how it's going to be applied, but right now, if the restitution is still owing, go for it anyway. Okay, penalty for driving without having a license. A valid license is reduced. Now, this is the unlicensed driver. This is not the driver who's got a license, but it's not in their possession. So this was a misdemeanor, but it could often be and often was reduced to an infraction. This now makes the first or second violation is an infraction every time. And it can be a misdemeanor after that, can be reduced to an infraction. Driver license suspensions for fail to appear now are effectively stopped. This is complex. The VC 40509 and 40509.5 are repealed. Those statutes permitted the court, and clerks would often do this. If the person was FTA on a traffic citation, they reported to DMV under those statutes. DMV, getting that report, suspends the license. The statutes that require that permit the reports are repealed. The theory is DMV can no longer suspend the license for that reason, because they needed the report to suspend it for that reason. They don't get the report, they can't suspend the license. This effectively stops it. It doesn't completely. There are still some in the pipeline, and there may still be some other exceptions. Uncodified section 27 says any suspension of a license under these statutes has to be terminated anyway on January 1st, 2027. Why wait 4 years? Because DMV is improving their computer systems. They think it's going to take them that long to catch up. Client trust account protection program. This isn't a criminal law, but you're all going to have to go through this, answer questions about if you've got a trust fund. Jurors are entitled to free public transit. There are so many exceptions to this. We'll see how it gets applied, but they're supposed to get bus fare or the equivalent if there's a bus that goes near. Okay, every once in a while you need to know this. All of the statewide COVID emergency measures have been rescinded or sunsetted. There are still a whole whack of local measures. I don't cover those, but the statewide ones are gone. This is one that's not operative until July 1. Juvenile interrogation by law enforcement is further limited. What you need to know is that the Legislative Council Digest says it's limited January 1st, but the law says July 1st. It basically says that cops can't employ threats, physical harm, deception, or psychologically manipulative interrogation tactics, tough phrase, as specified during custodial interrogation of a juvenile. There's a new court holiday, Juneteenth, June 19th. The end of slavery is celebrated. Now, there are other statewide holidays that have been enacted also. Lunar New Year, Chinese New Year, Lunar New Year, but it's not a court holiday. Juneteenth is. So there we are. Thank you for listening. I will stay for a few minutes and answer questions. I didn't have to answer any so far, so I'm willing to stay, but thank you all for listening. It's been a lot of fun.
Thank you so much, Garrick. This is where we would give you a round of applause if anybody could do that, or if we were in person. I know that I'm glad to stick around for a minute as well if anybody has any questions before rushing off, if you don't have afternoon court. Oh, we have a note that Alyssa's also clapping for you, Garrick. So,
oh, good. Thank you.
I know I have the one question that kind of came to mind. I didn't want to interrupt at the time. Was we now have the ability to get some information about, you said like the demographics of charges that are charged to different individuals. What does that look like?
It's too soon to say precisely what that's going to look like. It's a somewhat complex law, and I didn't study it in detail. The way to really find this out is to go to the Office of State Public Defender website, and they list their listservs. You have to scroll down on that website, and there will be a listserv for Racial Justice Act. And they will have a lot of material on this. I'm sorry I'm unable to answer this in more detail.
No problem.
Any other questions that I can't answer or that I can? No, you're seeing none in the
I don't see
so
any.
forth. Well, thank you all very much. I appreciate it.
Thank you so much.
Thank you.
Yes.